and lead us to campsite number 12.
And you did not do an interrogation of Mr. Rodriguez?
No, we didn't see the need to at that moment. We ran a background check and also a sexual offenders list check on him, though.
And you also had Mr. Rodriguez prepare a statement?
We did. We had him go back to the station to do so.
But Mr. Rodriguez was never considered a suspect?
No, from evidence and other statements collected, we did not find a need to interrogate Mr. Rodriguez.
But he had seen Parker Page on the weekend of July 14th and 15th?
He had.
And Mr. Rodriguez also gave you information of a list of campers that were on his property?
We were able to figure out some of the campers who were on his property, yes.
Exactly, Detective Chesney. You can't be 100% sure that the list that Mr. Rodriguez gave you was comprehensive.
We believed it to be comprehensive. We didn't run into many campers that weekend while we were there, so we took his good word.
But you have no evidence of security on the trail?
No, we didn't find any of that.
You have no evidence of any cameras on property?
No, we did not find evidence of cameras on property.
So you cannot be sure that the people on that list were the only people on Calkins Campground on the weekend of July 14th and 15th?
No, we cannot be 100% positive, but between discussing with Mr. Armani and also walking through the campgrounds with our search party, we were able to round up as many campers we could.
And let's talk about another one of those campers. You spoke with Kelly Dews on the weekend of July 14th and 15th, correct?
Yes, Mr. Dews led us to the Chrome Loop overlook.
Yes, Mr. Dews led you to the exact location of Parker Page's body.
Yes, he had informed us that he had heard them arguing there, Jordan Ryder and Parker Page, the day prior.
But he himself did not tell you how he knew this information right away.
No, not immediately. He had just stated that he had heard them arguing there.
And you did a background check on Mr. Dews.
We did.
And you looked through, and you did ask Mr. Dews for a statement.
Yes, we had him meet with one of our officers to go back to the station for questioning, yes.
But despite knowing exactly where Parker Page was on July 15th, Mr. Dews was never considered a suspect.
No, yet again, we didn't find enough evidence nor other witness statements that linked Mr. Dews and Parker Page alone at the same time.
Now, Detective Chesney, I'd like to talk about another camper that you knew was on the campground on July 14th. You knew that Cameron Lee was on the campground July 14th, correct?
Yes, we did. We were able to get a hold of Mr. Lee. He was in Aruba, I believe. We had left him a phone call and we had a police escort wait to come pick him up when he came back.
Exactly. You were aware that Mr. Lee left the country after July 14th.
Yes, which is why we had the police escort come to pick him up and retrieve him from the airport directly and bring him to the station.
However, when Mr. Lee arrived at the station, all you did was ask for a written statement.
Yes, we had them walk through a written statement.
And you did do a background check on Mr. Lee.
We did.
But Mr. Lee was never interrogated.
No, yet again, we did not find any evidence of Mr. Lee being isolated with Parker Page, nor any of the pieces of evidence that we retrieved.
Mr. Lee was never considered a suspect at any point.
No.
Now I'd like to move on to another witness that you spoke to that had a correlation with Calkins Campground, Remy Mouchard.
Yes, Remy Mouchard is the owner of the cafe down the road. They were able to call in about the cell phone.
And you were not able to speak to Remy Mouchard on the day of July 15th?
No, we were not aware of their contact directly at that time. It wasn't until Ms. Mouchard had informed us.
Ms. Mouchard called you a week after July 15th?
Yes, Ms. Mouchard had seen an advertisement we put out for any relative information, and she had retrieved the cell phone from her cafe.
But on the day of July 15th, you released an Amber Alert to the entire city of Midlands.
We did.
You also released a press release to the entire city of Midlands.
We did.
Midlands had information that Parker was missing for a week by the time Miss Mouchard came forward.
Yes, I'm not sure why Miss Mouchard didn't come forward sooner. I can't be certain, however, she was able to give us that piece of evidence and her statement, and we also ran our background checks on her.
Miss Mouchard asked you multiple times about a tipster reward.
Yes, she did ask about a reward. We were offering in that moment, and she was able to supply us with the cell phone as well.
In your eyes, she was significantly more concerned about the money.
She did seem concerned about the money, but yet again, she gave us Parker Page's phone, and she was able to give us a statement, and through our investigation, we saw no reason to see her as a suspect.
Exactly, Detective Chesney. A week later, Remy Mouchard had possession of Parker Page's phone.
Yes, she had informed us that she had found it recently.
And you never interrogated Remy Mouchard.
No, we did not see a reason to interrogate Remy Mouchard, for the reason being that there were no eyewitness statements that placed Miss Mouchard and Parker Page in an isolated scenario such as Mr. Ryder and Parker were.
Despite having possession of one of Parker Page's belongings a week later, Remy Mouchard was never considered a suspect.
From our understanding, Remy Mouchard had contacted the police directly after finding the phone.
But lastly, Detective Chesney, you only conducted one interrogation in this investigation.
Yes, that's correct.
You only had one suspect in this interrogation, or in this investigation.
That is correct.
And that was my client, Mr. Ryder.
Yes, that is where our best evidence came, and that is also what we found connected him to.
Though you did speak to almost everybody else correlated with Calkins Campground that weekend,
Yes.
and knew that many of them had seen and interacted with Parker Page.
Yes, but yet again, we did not see that any of those other witnesses had as much isolation connected to Parker Page, and they were not together.
Thank you, Detective Chesney. No further questions.
Thank you, counsel. Redirect for this witness.
I have no redirect, Your Honor. I just ask that Detective Chesney can step down.
You are excused. Thank you. Counsel for the state.
Yes, Your Honor. At this time, the state calls Mr. Kelly Deuce to the stand. Before we proceed, permission to set up the well for use of the demonstrative.
You have free use of the well.
Yes,
Your Honor, may I move during this draft if needed?
I addressed that in
Yeah.
pre-trial. You can move to see anything that you need to see.
Thank you.
May I proceed?
You may.
Good afternoon, sir.
Good afternoon.
Could you start off by introducing yourself to the members of the jury?
My name is Kelly Dews.
Mr. Deuce, I want to start off by giving the members of the jury the chance to understand why you're here today. Are you currently employed?
I had a daytime job a long time ago, but I discovered that I fell in love with hiking, so I decided to take that to be my full-time job, and I'm a social media influencer now, excuse me. I have Snapchat, Instagram, Twitter, YouTube, all those things where people can follow me and check up to see what I'm doing.
Well, Mr. Deuce, how'd you get involved in today's case specifically?
Like I said, I'm an experienced hiker, and I've been in Midlands for the first part of 2018, and I took a trip out to Calkins Campground in July.
Well, let's talk about that trip that you made to Calkins Campground. Can you tell us what it was like when you first arrived there?
It was a scorcher every day. It was about 96, 97 degrees easily. It was hot. Like I said, I'm an experienced hiker, and I even noticed how hot it was. And just because of the heat, I could probably assume that nobody was going to be there. And when I got there, there were very few people at the campground.
Mr. Deuce, would you recognize a blown-up version of the map of that campground if I were to show it to you today?
Of course.
Your Honor, at this time, we'd like to omit Exhibit 23, the demonstrative version of this map.
Any objection to that?
No objection. The defense has waived our objections to this particular document.
Then Exhibit 23 is received without objection.
Yes, Your Honor. Now, Mr. Deuce, what trails did you hike on while you were at Calvin's Campground?
Well, the first trail that I hiked on was the Wagner Loop, and that seemed to be oddly novice for me, so I tried the Lecron Loop.
What was the Lecron Loop like?
Not novice, I can tell you that. It was difficult. There's a lot of elevation differences, it's steep, a lot of debris, rocks, sticks and stones you can trip over, and if you're not wearing the right shoes, you can definitely hurt yourself.
Did you see anyone else that day that decided to take that difficult trail?
I did run into Jordan Ryder and Parker Page, like right around the forefront of that trail.
Permission for the witness to step down and make use of the demonstrative.
Go ahead, sir.
And Mr. Deuce, can you circle on this map where you saw Mr. Ryder and Parker Page on the Calkins campground?
I would say it was just about at the corner where I would begin the loop.
First for the witness to retake his seat.
Go ahead.
Did you see them any point later in that day?
Yeah, I did. I interacted with the two twice actually. The first account was when I was making my way to the Lacrone Loop, and I like to see other hikers outside, you know, doing the same thing that I love to do. So I wanted to introduce myself to the two, but the situation was odd because I introduced myself and Jordan didn't really have much to say to me. And then I wanted to find out the little girl's name, and she had on a soccer jersey that said Morgan on it. And I called her Morgan, but Jordan corrected me and said that her name was Parker. And after that, it got strange, I'll say. Jordan had been slightly visually irritated with Parker because she had been waving around a hiking staff, and she turned around and said, "Quit it." I hadn't said anything up until this point either, and then afterwards, after the comment of "quit it," Parker Page took the hiking staff and poked it into the back of Jordan Ryder's calf. And consequently, Jordan Ryder turned around, grabbed the hiking staff out of Parker Page's hand, and grabbed it with so much force that Parker Page had almost fallen over. And I had seen this with my eyes.
Well, where did you see that happen?
That was by the Lacrone Loop.
Well, Mr. Deuce, was that the last time that you saw Mr. Ryder and Parker Page?
Oh no, I made it my job to get out of that situation. I'm not a very confrontational person myself, so I made sure to tell them good luck on the trail because I myself know how difficult it is, and I just wandered around for maybe 15 minutes to let things calm down between the two.
Well, what happened after you came back to that area?
It was an hour later possibly, and it was so odd because they were doing the same exact thing, just louder. You know, they were going back and forth, a little more aggressive this time, and Parker Page was obviously aggressive with her dad and said something
Objection,
along...
speculation, may I be heard?
Go ahead.
Your Honor, I believe that the witness is peering into the mindset of Parker Page by saying that she was being aggressive. No foundation has been laid as to why the witness believes that she was aggressive, what actions she was portraying, or maybe even facial features.
May I respond to that, Your Honor? We actually have heard this foundation from this witness. He already spoke of what Parker Page and Jordan Ryder were doing. He said that Parker was poking that the hiking staff into the back of Mr. Ryder's calf, and also that they were arguing in the midst of this. That's enough foundation to lay that for Mr. Deuce to say that Parker was aggressive and angry at that point in time.
May I respond, Your Honor?
Sure.
I have two separate points. One, the opposing counsel just cited another instance that Ms. Dews met, or Mr. Dews met Parker and Jordan. The moving of the hiking stick was not the same particular incident. And number two, we haven't heard anything about an argument. In fact, the only testimony elicited from Mr. Dews was that they were going at it. Nothing about an argument or anything along those lines.
May I respond to that, Your Honor?
Sure.
Well, what Mr. Dews did say was that they were arguing just like they had been before. And what Mr. Dews is saying is that when they were going at it, that they were arguing just like they had been before.
I think the colloquial meaning of going at it in this respect is pretty clear.
Yes,
I think the foundation that you're saying they need to lay has already been laid, and so the objections are ruled.
Yes, Your Honor. Mr. Dews, can you tell us what happened after you saw Mr. Ryder and Parker that second time?
Well, again, to reiterate, I'm not a confrontational person, so I made it my job to leave the location that they were at, and I had walked back to the Calkins campground.
Did you ever hear from Parker again that day?
Here, yes. Sadly, I had walked about 15 minutes away, and I heard yelling from Parker, and she was still having...
Objection, lack of personal knowledge, may I be heard?
Okay?
The witness just said, I heard Parker yelling. And he also said that he was not seeing her. He walked 15 minutes away. how do we know that this was in fact Parker Page? There was no visual, nothing has been identified from her voice. He has no knowledge that it was in fact Parker Page.
May I respond to that, Your Honor?
Go ahead.
Pursuant to Midland's Rules of Evidence 701, it has to be in a witness's rationally based perception to state that he knows that this was Parker Page. Now, he's already stated that he interacted with Parker several times that day, had heard her speaking, and it's in his rationally based perception that 15 minutes later, he can hear the same voice and say that it was Parker. Now, if opposing counsel would like to bring up this on cross-examination, this goes a little bit more towards weight and not admissibility today, Your Honor.
Counsel, what is the evidentiary standard for the witness to speak about something like this?
It's by preponderance of the evidence, Your Honor.
Close to a no cigar. Regardless, the objection's overruled. I think counsel is correct that you can bring this up with us.
Yes, Your Honor. Oh, Mr. Drews, what did you hear Parker say?
Yeah, to continue, she said something like, "I wish you had never gotten out of jail."
Objection, hearsay.
Why is this not hearsay, counsel?
Your Honor, these statements are going to the subsequent action of Jordan Ryder immediately afterwards. We believe, Mr. Drews believes that this conversation was being had between Parker Page and Jordan Ryder, and you're going to hear what immediately happened after that, after Parker Page made these statements.
May I respond?
Go ahead.
Your Honor, there's no need to elicit this statement, then only the subsequent action of it. This particular line of testimony is in fact hearsay, and only the subsequent action is needed to be heard.
May I respond to that, Your Honor?
Go ahead.
If it's the state's contention that Mr. Ryder killed his own daughter, it's most certainly important to hear what led him to hurt his own daughter, and that's why we have to hear the specific words that came out of Parker Page's mouth that could make him angry enough to have such actions. That's why this is relevant.
May I respond?
Go ahead.
I have good faith and reason to believe that if they are in fact using this for the subsequent action of the listener, they're using it to show that perhaps Mr. Ryder then used a hiking stick to shove Miss Page off a cliff. Mr. Dews may make an offer of proof.
Go ahead.
Mr. Dews has no knowledge of this, and therefore there is no subsequent action because he has no knowledge of a subsequent action.
May I respond to
Go
that,
ahead.
Your Honor? Your Honor, it's not just the subsequent action of Mr. Ryder, but also of Mr. Dews, and he can most certainly attest to what he experienced immediately after those statements were made. May I make an offer of proof?
Go ahead.
Mr. Dews is going to go on to say that immediately after Parker made those statements in the same area in which Parker and Jordan Ryder were, that he then heard a scream, and immediately afterwards, he went to go see what happened. That's all the subsequent action of both Mr. Dews and Mr. Ryder, and is relevant for the jury members to hear.
I think based on the arguments, the objection is overruled.
Yes, Your Honor. Mr. Dews, what did you hear Parker saying?
Like I said, she said something about, "I wish you had never gotten out of prison. I should have stayed with Corbin." This was distinct enough because I had obviously had earlier interactions with the two. And just after that was this ear-piercing scream, obviously human. And I turned around, I called to see if anyone needed help. I probably should have went back, knowing what I know now, but I just tried to stay out of family business and confrontation, and I called back to see if anyone needed help and went right back to the campground.
Mr. Dews, let's talk about the next day. Were you ever approached by police officers?
Yeah, that morning, while I was getting some of my thoughts together, Detective Chesney approached me with a photo of Parker Page, and I immediately knew something had been completely wrong.
Well, where did you take the detective?
I took them right back to the last spot I'd seen the two. They were there for over an hour and a half, I could assume, the day before, so that's the last thing I could really tell them.
Did you all find Parker there?
I took them to the spot, and several hours later of searching, yes, they unfortunately found Parker Page's dead body.
Thank you. I have no further questions at this time, Your Honor. Would you like me to deconstruct the demonstrative?
Yes, thank you. Yes, Your Honor. May I proceed?
Go ahead.
Good afternoon, Mr. Dews. I'd like to begin by starting where you were at and what happened when you went to Calkins Campground. When you entered, you tried to check in with the owner of the campsite, Armani Rodriguez.
Correct.
Armani wasn't there.
No, it was not.
And so you decided to start hiking anyways.
Yeah, Armani and I know each other, so I figured I would run into him later.
Is it your testimony today that you and Armani have a working relationship?
I have interacted with Armani before at the Calkins campground, yes.
Mr. Ryder, moving on, when you signed in, you were supposed to pay before you went on the campsite, right?
Objection, Your Honor, to relevance. Would you like me to explain?
Counsel, how is this relevant?
Yes, Your Honor. It is our theory as the defense today that there could have been other people on this trail. Now, if Mr. Dews was allowed to get on this trail without paying, this is going to show that it's possible there could have been other people not investigated as suspects for this particular case.
May I respond to that, Your Honor?
Okay, sure.
Well, Your Honor, if that's what opposing counsel is attempting to use this for, I don't believe that it's proper for them to bring that out through this specific witness. Mr. Dews is going to actually go on to testify through this line of questioning that he actually did end up paying later that day and was staying at the cabins. As a result, what we heard from Detective Chesney just a moment ago is that she received the guest list of all of the people that were staying on the campsites. And that argument that there were other people that were there, it's not made clear through the testimony of Mr. Dews.
I don't think it necessarily needs to be made clear through the testimony of Mr. Dews in order for counsel's point to be made, so the objection's overruled.
Yes, Your Honor.
Mr. Dews, you were able to start hiking without officially paying for the hike, right?
Technically, yeah.
And when you went on the hike, you didn't see any security.
No,
There was no police officers around or law enforcement.
not yet.
There weren't any video cameras.
No,
There weren't any barriers.
no.
And so it could be very easily accessible for anyone to walk on that trail.
Sure, it's a hiking trail, so it's outside. A lot of people could just happen to come along the trail.
Exactly. It's public, right?
Yes.
Thank you, Mr. Dews. I'd now like to move on to your interactions with Parker and Mr. Ryder. When you first encountered them, it kind of seemed like they were maybe a little bit frustrated with each other.
More than frustrated, but yes.
Well, earlier you stated that you saw Mr. Ryder kind of use a hiking stick and maybe put it in Parker's direction, right?
100% with the hiking staff in Jordan's, or Parker's direction, excuse me.
And to be clear though, that hiking stick never touched Parker.
Made no physical contact, but there was an effort to make contact from what I saw.
But there was no contact, right, Mr. Dews?
No direct contact, no.
And later on, you say that you saw them up towards the loop, right?
Yes.
But it was heavily wooded.
As a hiking trail would be, yes.
Exactly. And like you said, there were lots of rocks and trees in the way.
Of course.
And you walked 15 minutes in the other direction of them.
Right.
And that's when you claimed that you heard a scream.
Yes.
But you couldn't see the person scream
I could not.
because it was so heavily wooded.
I had walked away about 15 minutes and I'm an experienced hiker, so I made my distance, yeah.
Exactly. So you were pretty far away, 15 minutes away from that particular location.
Right.
So you cannot be, with any degree of certainty, you cannot place them at a precise spot on that trail, right?
Well, I could because I had taken Detective Chesney back to the very spot they had been at the next day, so I had assumed that the screaming and yelling had come from the same location.
But Mr. Dews, at that particular time, when you had walked 15 minutes away from them and it was heavily wooded, you cannot be certain that what location they were in.
Not pinpoint, 100% no.
Exactly, and you couldn't even be certain that Mr. Ryder was even there.
I guess not, no.
Thank you, Mr. Dews. No further questions.
Thank you, counsel. Redirect?
No redirect necessary, Your Honor. I just ask that my witness be allowed to step down.
You're excused, sir. Thank you.
Thank you.
Counsel for the state?
Yes, Your Honor. But before we begin, may we briefly set up a demonstrative?
You don't have to ask for permission for that.
this time, the state calls Dr. Quincy to the stand. May I proceed?
You may.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Hello, my name is Dr. Rose Quincy.
Dr. Quincy, why are you here today?
I was called to testify because I was the coroner who performed the autopsy on the late Parker Page's body.
What do you do for a living?
Well, after graduating from The Ohio State University, I spent my med school years at the Virginia School of Medicine. I've since practiced medicine across the Midlands and actually in 2015 was appointed the Chief Medical Examiner of Breckinridge County in Midlands, and I have held that position since.
Did you review any evidence before today's trial?
Yes, in preparation for today's trial, the majority of my conclusions were based on the autopsy itself that I performed on Parker Page's body. However, I also relied on her medical history and several pieces of evidence provided to me by Detective Chesney.
And was this enough evidence to come to any type of conclusion?
More than enough. These are the typical kinds of materials myself or other medical examiners would typically rely on in cases like today's.
Did you apply any type of principle or method when conducting your autopsy?
Yes. When I came to my conclusions for today's case, I applied and did the standard autopsy on the late Parker Page's body.
Is this method reliable within your field?
Absolutely. I performed autopsies the way that it's taught in med school, the way that I have performed over 1,000 autopsies that I've performed in my career, and the standard and widely accepted way of performing autopsies.
Was this reliably applied to the facts of this case?
Yes, absolutely. I performed autopsies the way that they are always performed.
So I want to start off talking about your standard autopsy. How would you typically begin?
Well, the autopsy process consists of two parts. We start with an external examination and we move to an internal examination following that. And today I actually brought with me a blown up version of a body diagram I typically use to further illustrate my autopsy process.
At this time, may the witness be allowed to step down and make use of a demonstrative?
What is the demonstrative?
The demonstrative is a blow-up of the body diagram she used in conducting her autopsy.
And are we publishing this to the jury?
This is just for demonstrative purposes. However, if your honors would like us to publish it to the jury, that would be.
What I mean is the jury going to see this in court, or is it just going to be?
Yes, your honor, it could be published to the jury.
Okay. Any objection to that?
No objection, Your Honor.
Okay. Go ahead then.
So, Dr. Quincy, what happens in the external part of an autopsy?
Well, when I initially looked at Parker Page's body, I noticed severe ecchymosis or bruising all along the right side of her body. And then actually something that I found quite interesting on the external examination was there was one injury sustained to the left side of Parker Page's body.
And what was so interesting about that?
Well, this injury, it didn't quite look like any of the other bruises or injuries found present on Parker Page's body. It was in a very specific half-moon shape found present on her left clavicle, and honestly, this bruise was quite the puzzle for me, so I moved to the internal examination to look for further clues.
What happened in the internal examination?
I began by opening the body with a Y incision, and once I opened Parker Page's body, I noticed several healed and unhealed fractures found present within her body.
What were those fractures?
The most notable were here in her right ocular region. She had 6 broken ribs on her right side, and then her right ankle was also broken. And then what raised several red flags during the internal examination was there was actually a fracture to match that bruise that I had noticed in the external examination.
Could you tell us a little bit more about those red flags?
Well, the first concerning factor for me when I was observing this fracture was the fact that this injury, it didn't look like any of the other injuries found present on Parker Page's body. Not only was this in a completely different and very specific half-moon shape, it was a different color, a different size, and this was the only injury sustained to Parker Page's left side of her body.
So could you tell us what all of that means?
Yes, all of these can be indicative of the fact that this was from a different source of trauma than the other bruises found present on the right side of her body.
If the bruise came from a different source, do you have any idea what could have caused it?
Well, that's what I kept asking myself over and over again. What could have caused this very specific bruise found present on this little girl's body? And it wasn't until a few days after the actual autopsy had been completed that I was approached with several items that had been found within the defendant's tent. And after thoroughly examining all of these items and comparing them to the injuries found present on Parker Page's body, the only conclusion I was able to come to was the capped end of the hiking staff I was given was an exact match to that injury found present on her left clavicle.
Would you recognize that staff if I showed it to you today?
I would.
I'm approaching the witness with what's been marked as Exhibit 17. Approaching opposing counsel with what's been marked as Exhibit 17. And permission to approach the witness with the same. Dr. Quincy, what have I just handed you?
This is that hiking staff that I analyzed.
Does that appear to be a fair and accurate copy?
Yes, absolutely.
Has it been changed or altered in any way since you've last seen it?
No, this is definitely the same staff that I analyzed in the lab.
At this time, the state moves to enter Exhibit 17 into evidence.
Any objection to 17?
No objection, Your Honor.
17 is admitted without objection.
Yes, Your Honor. Dr. Quincy, how could that staff have caused Parker's bruise?
Well, in order for this staff to have caused that bruise found present on Parker Page's left clavicle in both the same shape, location, and color, the staff would have needed to hit her with substantial force, enough to break the collarbone from above in a motion similar to this.
Thank you, Doctor. Permission to approach the witness and retrieve Exhibit 17?
You may.
And at this time, we ask that the witness can retake their stand. Would Your Honors like us to publish this to the jury? I see that the bench is a little bit full.
Go ahead and keep it at council table, thank you.
Yes, Your Honor. So, Dr. Quincy, I want to talk about Parker's time of death. Was that something you looked for in your autopsy?
Yes, absolutely. When I conducted the autopsy, a standard procedure is coming to a conclusion on the time of death. And by examining which phase of rigor mortis Parker Page's body was in, I was able to come to a very clear answer.
What's rigor mortis?
Rigor mortis is the body's natural process of stiffening after the body has passed away. It initially becomes very stiff and then slowly loses that stiffness over time. And by looking at which phase the body is in when I conduct the autopsy, I can come to a very accurate conclusion around what time the body died.
And what was your conclusion on Parker's time of death?
Well, based on the phase of rigor mortis that was found present, I was able to turn
Objection,
to...
Your Honor. Lack of foundation.
What foundation do you think is lacking, counsel?
How the method reached the conclusion, while the method's been stated and a conclusion's been drawn, there's no analysis on how that method got to that conclusion.
Counsel?
May I respond to that? Dr. Quincy already stated that her standard autopsy method was what she used to reach all of her conclusions. Now, this may be a different part of her autopsy, but it was still a part of the autopsy that she used. Furthermore, she also elaborated that she used the process, that she examined the state of rigor mortis in order to reach this conclusion. Between the rigor mortis analysis and her standard autopsy, this is foundation necessary to reach her conclusion.
Response in those rounds.
You may.
Your Honor, though she stated that she used this analysis to reach that conclusion, she's not stated how she used that analysis or what parts of the rigor mortis analysis led to that conclusion. While she said that this is the conclusion she used, she's not stated how she actually used it.
Your Honor, may I respond on those grounds?
You may.
It's not necessary for Dr. Quincy to say how she reached this exact conclusion. She's already qualified her method, and in order to state her conclusions, she is not required to disclose every underlying detail that led her to those conclusions, as can be seen in Rule 705.
Counsel?
Rule 705 states that that is only with the judge's approval.
Okay, well, I approve it, so the objection's overruled.
Yes, Your Honor. So, Dr. Quincy, what was your conclusion on Parker's time of death?
By looking at the stiffness present within Parker Page's body, her body was consistent with dying 19 to 21 hours prior to the examination, placing her time of death between 4 and 6 p.m. on July 14th.
And what was your overall conclusion in today's case?
As the chief medical examiner of Breckinridge County in Midlands, I ruled Parker Page's death a homicide. She likely died between 4 and 6 p.m. on July 14th due to an injury sustained on her left collarbone by that hiking staff, which unfortunately led to her fall and tragically her death.
Thank you. And with that, we have no further questions.
Thank you, counsel.
Would opposing counsel like us to remove the demonstrative?
You may remove the demonstrative.
Counsel?
Yes, Your Honor. May I proceed?
You may.
Dr. Quincy, on your direct examination, you stated that Parker's rigor mortis placed her time of death 19 to 21 hours prior to her death, between 4 and 6 o'clock. That's correct? Is that your testimony today?
Yes, I utilized the standard body temperature formula and the rigor mortis process in order to narrow down my conclusion as narrow as it could possibly get.
Dr. Quincy, you said rigor mortis placed her time of death between 4 and 6 o'clock, right? Specifically rigor mortis.
Yes, the standard autopsy, there's several ways to check time of death. Rigor mortis in itself is the most effective, which is why that is what I chose to bring to.
And your testimony today is specifically rigor mortis placed her time of death between 4 and 6 o'clock. Is that correct?
The standard body temperature formula narrowed it down to 4 to 6. Rigor mortis gives us a very good idea of around which time the body died. However, the formula and the rigor mortis together provide